Below is an extract from Ripple's notice of the additional authority, which was expressed by defense lawyer James Fawn in reply to the judgment that was just handed down in the Binance case. Despite the fact that the home rule is only 7 pages long, the structure that is outlined in it does not allow for the accurate representation of intangible digital assets. In addition to the decision that was made by the government to monitor this multi-billion-dollar industry through the administration of lawsuits from one circumstance to the next, the coin-by-coin method is not likely to be effective and may result in inconsistent results, which would deprive significant parties and their potential customers of their ability to obtain accurate information. As a brief introduction, I would like to bring to your attention the fact that Judge Amy Berman Jackman has recently dismissed the allegations made by the United States Securities and Exchange Commission that the secondary market transactions involving the BNB token satisfy the criteria of the Hoyt test. This is something that I would like to bring to your attention. XRP programmatic sales were the subject of the verdict that Judge Annalisa Torres handed down in July of 2023. This verdict served as the basis for the conclusion that the court reached, in a manner that appears to be in direct contravention to the precise directives that were made by the Supreme Court. The procedure that was utilized by the SEC appears to be, according to the recommendations of legal professionals, the court is likely to agree with the verdict that was reached in the Ripple Labs case. This is because the verdict was made already. It is likely that the decision that the court reached in this particular case will dissuade the commission from appealing the programmatic sales of XRP. This is something that might happen. Ripple took advantage of the opportunity to assert in its notice of supplemental authority that the court's determination of a strict liability violation for certain Ripple sales, despite the fact that it was significantly fewer than the SAC claimed, does not constitute willful breaking of the law or justify the use of severe punishment as required by the law. This assertion was made in response to the lack of clarity that existed prior to the ruling. At this very moment, the Securities and Exchange Commission is seeking that a total of $2 billion be returned to consumers. Nevertheless, Ripple is just proposing $10 million. If the verdict is delivered down on July 31st or July 13th, which would be the historic ruling date that Judge Annalisa Torres is slated to hand down, economists believe that a favorable settlement might result in the price of XRP reaching $1 or higher. This is because the verdict would be handed down on the historic ruling day. In the event that the ruling is handed down on any of those dates, this would be the applicable scenario. To provide some background, Judge Annalisa Torres came to the conclusion that Ripple has broken the United States Securities and Exchange Commission's rules by selling unregistered XRP to institutional investors. For the time being, investors were waiting for the court to make a decision regarding the penalty that Ripple must pay for violating these guidelines. Payment of the fine was mandated to be made by Ripple. There was no new information that came to light regarding the Ripple case that was kept hidden, which could have had an effect on the demand for XRP among purchasers. The potential fine that Ripple may be subjected to for breaking a securities legislation could be anywhere from $10 million to $2 billion, and it could even include an injunction that would ban the sale of XRP to institutional investors located in the United States. The corporation included a discussion of these fines in the initial briefing that it offered on the various available remedies. A request for an injunction and a demand for a fine of more than $2 billion had already been submitted by the Securities and Exchange Commission in the month of March. A request for a penalty in the amount of $10 million was submitted by Ripple in response to the opening brief received. During the opposing brief, other remedies were explored, and it was feasible to evaluate whether or not the sales of XRP in response to a complaint were institutional transactions that violated the laws governing securities in the United States. Despite the fact that the cryptocurrency market is eagerly anticipating the verdict, there are still a number of factors that are being taken into consideration. In this regard, one of them is the Securities and Exchange Commission's intention to file an appeal against the decision regarding XRP programmatic sales. After the end of this case, which was reached in July of 2023, it was decided that XRP programmatic sales do not satisfy the third component of the Howe test. This result was made after the verdict was reached. Should the price of XRP experience a surge prior to the retreat period, would the Securities and Exchange Commission be inclined to lodge an appeal against the decision that was made about the programmatic sales of XRP? Is it feasible that the Securities and Exchange Commission's decision in the instances involving Binance and Terraform Labs has prevented the company from appealing the verdict? A misconception over the classification of XRP as a commodity or security, which is against the law, has caused the regulatory atmosphere to become convoluted as a result of two decisions taken by the Securities and Exchange Commission against cryptocurrency courts. Quan, the founder of Terraform Labs V, was found to have violated the regulations that regulate securities in the United States by selling unregistered terms in Luna, according to the ruling that was handed down by Judge Jed Rakoff in December of 2023. The decision that was handed down concerning programmatic sales of XRP served as the foundation for the finding that Judge Torres had previously reached, which Judge Rakoff deemed to be incorrect. As a consequence of the decision that was made in the Terraform Labs case, the Securities and Exchange Commission is now in a more advantageous position to file an appeal against the decision that was announced regarding programmatic sales. That the SEC's efforts to reject the conclusions of the XRP programmatic sales might be ineffective is a possibility that should be taken into consideration. On the other hand, the court will make a decision regarding the second bankruptcy case in June of. In light of the decision made by Binance, CC's chances of successfully appealing Binance have been severely undermined. The claims that were brought against Binance by the Securities and Exchange Commission were rejected by Judge Amy Berman in the month of June 2024. Jackson cited the performance of Binance Coin's secondary sales as evidence that the cryptocurrency passed the home test. This was in contrast to the conclusions that Judge Rakoff expressed regarding the ruling, which were made by the programmatic sales judge. Jackson offered an informed forecast about the SEC's position, stating that it appears to contradict the specific posture that the court adopted in the Ripple Labs case in reaction to Binance's judgment. Jackson made this prediction after taking note of the verdict. Following his careful consideration of the directive, Jackson arrived at this conclusion. According to Stuart Alderode, the chief legal officer of Ripple, investors may continue to be concerned about the plans that the SEC has for an appeal and test buyer demand for XRP. Alderode stated that investors may continue to be concerned about these preparations. Despite the fact that the courts are able to see through the conflicting legal theories that have been put up by the Securities and Exchange Commission, this is the case. This is due to the fact that the muddying of the waters has led to confusion, which has prompted investors to be uncertain about the situation. Investors will have to wait for the final decision in the case against Ripple before the Securities and Exchange Commission (SEC) may make a decision on whether or not it would attempt to reverse the verdict relating blockchain technology XRP. Following the decision made by the Securities and Exchange Commission to give up its efforts to oppose the programmatic sales ruling, the door has been opened for an appeal against BIN's conclusion, which has the potential to restore XRP back to its previous price of $1. On the other hand, there is the possibility that an appeal may cause the price of XRP to drop to less than 40 cents, which would allow this cryptocurrency to successfully navigate the Bitcoin market. It is of the utmost importance that we remain current with the most recent information and observations that we possess by keeping oneself informed. It is possible that you will be able to adjust your trading tactics in response to the increasing activity in the courts of the United States with the assistance of real-time data and the opinions of professionals. Many people are experiencing a great deal of anxiety as a result of the market's feeble recovery from the gains that occurred in March and the continued waves of decline that have persisted since then. In the cryptocurrency markets at the moment, this is due to the fact that the market has not yet recovered from the gains that occurred in March, when it comes to the cryptocurrencies that have been affected the hardest by these declines. XRP has been slammed particularly hard. The value of it reached 38 cents today, making it the first of its kind. The fact that investors in XRP have been struggling against this decline for years is a sign that they have developed a sense of helplessness. The value of XRP has been impacted particularly severely. The following is a response to the recent statements that officials from Ripple have made regarding the collapse of XRP. David Schwartz, an official at Ripple, expressed his thoughts on the topic after being asked about it. Bitcoin is taking into consideration the issues that have been voiced by individuals who are a part of the Bitcoin community.